The open meeting law is a Massachusetts general law which is intended to provide transparency with regard to deliberations and decisions on which public policy is based. The law is chapters 30A, sections 18 through 24. The Attorney General's website has good discussion of this, as well as other materials and videos describing the details of the law. The law applies to public bodies established to serve a public purpose. These include multiple member boards, commissions, committees, and subcommittees, whether they are elected or appointed, and whether they are within the executive or legislative branches of the government. In Falmouth, we have a number of different public bodies. They're of two types. The first is elected, so the Board of Selectmen, Town Meeting, Planning Board, Trustees of the Public Library, School Committee, and Falmouth Housing Authority are all elected boards. Appointed boards include the Finance Committee, which is appointed by Town Meeting, and other boards which are appointed by the Selectmen. The Economic Development and Industrial Corporation is one of those. Here's a list of some of the boards appointed by the Selectmen. These vary in the number of board members that they have. Some may have as few as 3, others may have 5 or 7 board members. Typically, the board members are appointed by the Selectmen for a particular term, and the terms are staggered so that there is always institutional history on the board, people who have served longer than other new members, and that rotates. These are the other appointed members which are listed on the appointed boards which are listed on the town website. There are other public bodies within Falmouth that have representation, but they tend to be regional. For example, the Cape Cod Regional Transit Authority and the Steamship Authority involve multiple towns, and Falmouth typically has a seat on each of those boards, but they are typically have their own website and manage their own open meeting law compliance on their own website. The requirements of the open meeting law for public bodies include 3 things. Deliberations must occur in public with 48-hour advanced notice of such meetings and their agendas. A quorum of the board or commission must be present in order for a deliberation to be held and for a vote to be taken. And the minutes of the meeting must be kept and approved as an accurate record of the meeting discussion and vote. The advance notice requirement in Falmouth, typically meetings and their agendas are posted on the town website in the Agenda Center, and the link for that is listed here. They must be published 48 hours before the meeting is to take place, and note the agenda and the location and the starting time for that. Meeting notices and agendas may also be published in the Falmouth Enterprise or on bulletin boards at Town Hall, but our understanding is that the Agenda Center is the most important site. If the meeting is not posted there, then it may not be held, or if it is held, it will be in violation of the open meeting law. This becomes a little tricky for groups who are remote from Town Hall, and they may feel that they could post in their own location, but our understanding, again, is that the Agenda Center is the critical location for posting meetings and agendas. Meetings must be open to the public, and they are scheduled in locations and rooms thought to be large enough for the anticipated attendance. If the attendance exceeds the room capacity for some reason, then the meetings will need to be canceled and rescheduled for a larger meeting room, again with 48 hours advance notice, and the meeting room door may not be closed during the open meeting, because that would give the impression that it is a closed meeting. So for one example, there was a public hearing in the Zoning Board of Appeals which attracted a very large attendance, and the ZBA anticipated that and scheduled it for the Herman Room of the library rather than their normal meeting room in the Selectmen's meeting room. A quorum is typically a simple majority of members, so a 3-member board must have 2 members present in order to have a meeting or take a vote. A 5-member board must have 3 members present in order to have a meeting or take a vote. But some bodies require a supermajority of members for votes on certain issues. For example, a 5-member board or committee may not meet if fewer than 3 members are in attendance. If a supermajority is required, then 4 members would need to be in attendance and would need to vote unanimously in order for that decision to be legal. If a quorum is present, physically present in the room, other members who are absent may participate via electronic means. This is fairly rare, and I believe it is thought to be important that if they're participating via Skype, then they must be visible to the members in the room to be assured that it is that person who is speaking rather than someone else. The minutes recording the discussion and voting must be kept and approved by the public body, typically within several subsequent meetings. Some boards or commissions are more efficient at this than others. It is not required by the law that approved minutes be made available on the Agenda Center or posted publicly, but the law does require that they be kept and approved and kept on file for review by the public upon request. There are certain activities which may not occur under the open meeting law. So members of public bodies may not discuss cases or topics under deliberation privately among themselves. This is particularly important if the discussion includes or approaches a quorum necessary for decision. So in a 5-member board, for example, 2 members might have a discussion if they bump into each other in the grocery store or other location, and that would be okay. If 3 or 4 members bumped into each other and had a discussion privately, then that would be a violation of the open meeting law. This includes face-to-face discussion and electronic discussion. So in this case, email becomes quite treacherous, and again, 2 individuals might have a discussion by email about a topic, but you never know whether your email will be forwarded or shared with other folks. So email is particularly dangerous, and the boards that I'm aware of limit email discussion to individual members and the administrator. It's always one-on-one, and the administrator reacts to the request for information or question or topic individually and does not share that with the larger board until the open meeting is held in public, and that's when deliberation may take place. Boards are allowed to have closed-door executive sessions, but only to discuss personnel or salary issues or to prepare for a legal challenge to decisions where public witness might compromise the outcome. Meetings of executive sessions must still be kept. It's unclear to me whether those meetings of executive sessions are available to the public. I would think not. The law provides that newly elected or appointed members of the public bodies must receive copies of the Attorney General's Guide to the Open Meeting Law, their regulations concerning the open meeting law, and copies of all cases within 5 years in which the Attorney General has ruled a violation of the open meeting law has occurred. Individuals must receive that information shortly after appointment, and they have 2 weeks in which to certify to the town that they have received that information. If they don't so certify, then their appointment will be invalidated. And certification must be renewed with each reappointment to a committee. Individuals who serve on several committees probably don't need to certify the open meeting law information for each committee, but they must certify it for the first committee that they serve on and for their reappointment to that board, or if they choose to step off that board, then they would need to certify it for the boards that they remain on. This is somewhat flawed in that the certification does not guarantee that they have read the open meeting law, but the challenge of training each individual face-to-face as they're appointed is huge. The town has sometimes had general training sessions for people to understand the open meeting law. If you feel a violation has occurred, you must first notify the board, committee, or commission in question in writing and allow them 30 days to respond, either with their investigation of whether the violation did occur, and if so, a remedy for how they intend to resolve that. If you go 30 days with no response from the board, you should notify the Attorney General's office of the violation so that they may institute a process of investigation and remedy. There are 46 selected and appointed public bodies in Falmouth on the website, and 35 of these have posted meetings and agendas in recent months on the website. Some groups have not, possibly because they're short members and cannot reach a quorum. For example, the Sign Review Committee is a 7-member board, I believe, but has only 2 members currently, so they can never reach a quorum and have an open meeting. Some groups may meet only once or twice annually. Others are regional boards and post their meeting notices and agendas on their own websites. But the ones who have not posted recently would be, it's presumed that they either have not met, or if they did meet, they are in violation of the open meeting law. Many of these open meetings are televised on Falmouth Community Television, Channel 15, the government channel. These are the groups who are typically televised, and you would need to look at the TV schedule to see when those meetings would be broadcast or rebroadcast, since several of them are rebroadcast repeatedly. The League of Women Voters of Falmouth has an observer corps which monitors a number of local groups to be aware of current policy issues and to check on their respect for the open meeting laws. These are the groups that we currently have observers on. I note that the substance abuse observer is going to be departing from that position, so we will have an opening on that group. Additional observers are needed for other important committees. The planning board, I think, is a critical one, but since they meet every week, it's a daunting task for one person to commit to attending every session of that. But it would be certainly possible to split that responsibility among several observers to make it less onerous. Substance Abuse Committee needs a new observer. Coastal resilience is a critical issue, and that would be one which would benefit from having an observer. And Route 28 Advisory Committee is a hot topic and a very active committee right now, and they would benefit from having an observer, as well as the Finance Committee.